Please be seated. Proceedings are resumed. The Honorable the Premier continuing.
Thank you, Mr. Speaker. Mr. Speaker, when I took the adjournment, I had just dealt with the issue of overseas practices. Mr. Speaker, I want to move on now to talk about the section of the bill that addresses another long-standing controversial issue, and that is the issue of the number of years of post-qualification experience necessary before a foreign lawyer would be allowed to practice in the jurisdiction. Again, Mr. Speaker, many who discuss these matters appear to proceed on the basis that some of the practices that are observed in the jurisdiction are matters of law or regulation. The reality is that under the present legislation, anyone who is legally qualified and who meets the requirements under the law in terms of the jurisdiction in which they qualify, which is essentially all Commonwealth jurisdictions, and have been admitted, are entitled to be admitted to the Cayman Islands bar, and it must follow entitled before that to obtain a work permit. There is no requirement that they have to be Caymanian. There is no requirement that they need a Cayman partner. And over the course of recent years, we have had a significant number of these new law firms spring up which have no Caymanian involvement. Often, the blame is placed on the Immigration Board, or work as it now is, one of the boards there, or on the Attorney General, or on the government. But the reality is, under the current legislation, which some are still objecting to us changing, there are no regulations, there are no prohibitions, there are no provisions requiring the involvement of a Caymanian lawyer or that there is a minimum period of post-qualification experience. In practice, Mr. Speaker, the policy has been for many years that a minimum of 3 years PQE ought to be had by the applicant for the work permit, and that the board ought not to grant the work permit if the applicant has less than that. But it's nothing more than a policy, Mr. Speaker. This bill, if passed, will ensure that lawyers with less than 5 years post-qualification experience will no longer be permitted to be hired in the Cayman Islands. Only a Caymanian or the holder of a residency and employment rights certificate will be allowed to be admitted as an attorney at law if they have less than 5 years post-qualification experience. Mr. Speaker, for years there were those of us who advocated that given that we have a local law school, it was unnecessary and indeed undesirable to be recruiting overseas lawyers with less than 5 years PQE to fill what were essentially entry-level positions in law firms. Mr. Speaker, we are of the opinion that these entry-level positions must be reserved for young Caymanian entrants into the profession who should be properly trained up to ensure their upward progression. Hence, the 5 years PQE requirement. Mr. Speaker, the bill ensures that the legal services market will therefore remain open to our young Caymanian professionals, and the training and development regulations will ensure that they are provided with the necessary opportunities to develop and advance within the law firms. Mr. Speaker, allow me now to say a few words about consultation on this bill and the process thus far. Mr. Speaker, I believe we're all aware this effort spans more than 2 decades. We have had numerous attempts at getting a piece of legislation that would be largely acceptable to all stakeholders, but we have come to the realization that it is simply not possible to do so. This bill represents the best effort thus far that is acceptable to a significant majority, the vast majority of the stakeholders. As I've said before, Mr. Speaker, my own engagement with this effort goes back to 1998, and I can therefore say without fear of credible contradiction that this bill represents the best effort I have seen so far. It is not perfect, Mr. Speaker, as it understandably cannot address all the issues by all stakeholders, but it goes a long way to attempting to do so. And those matters that might not be fully spelled out in the bill are to be more fully articulated in a number of supporting regulations that will help to undergird the primary act. I will have more to say about those later, Mr. Speaker. But to continue on the issue of consultation, myself, the Honourable Minister of Finance, the Honourable Minister for Financial Services, the Honourable Minister for Commerce, the Honourable Minister for Education, and the Attorney General have at one point or another had meetings with various legal practitioners over the last many months to discuss the various iterations of this bill. We met with the Council of SILPA as well as one meeting with the Council of ALPA. We met, Mr. Speaker, with other industry We met, Mr. Speaker, with other industry stakeholders. My caucus also received presentations from members of the legal profession. I wish to emphasize that at these meetings with attorneys, there has always been what I would describe as a balanced representation of the profession. Meaning, Mr. Speaker, it was not just representatives from the larger firms, but instead all sizes, with firms, some with as few as only 2 attorneys. Mr. Speaker, during these meetings, as is to be expected, there were some who were not in support of some of what the bill attempts to do, some who also made suggestions on how to improve the bill, but I am happy to say, Mr. Speaker, that the vast majority do support the effort by the government as reflected in this bill today. Mr. Speaker, the Honourable Attorney General and I also had a meeting with the Honourable Leader of the Opposition, and all except one member of the official opposition was there. Unfortunately, Mr. Speaker, we were unable to meet with the 2 independent opposition members, although I'm advised that they might have met with members of SILPA on the bill. Notwithstanding this, Mr. Speaker, the government will listen to everyone's contributions and will happily take on board any reasonable suggestions on how to improve the bill. We will do so in respect of any suggestions from honorable members on the other side. Mr. Speaker, as you are aware, the bill, along with a detailed explanatory summary, was published on the 27th of October 2020, and because of the obvious public importance, was afforded 28 instead of 21 days consultation period. During the 28 days consultation period, we received a number of comments, including from the Chief Justice, a few sole practitioners and in-house counsel, and others. Mr. Speaker, all of those comments were carefully transcribed onto a spreadsheet alongside the relevant matching clauses of the bill. They were carefully evaluated, discussed, and decisions made on what were acceptable and those that unfortunately could not be accepted. Mr. Speaker, as a result of that exercise, which I personally led, we have produced a number of committee stage amendments that have been or will be submitted for your approval for circulation to members of Parliament. Committee stage amendments will deal with issues such as the structure of the disciplinary tribunal, the code of conduct, the structure of the council, the issue of in-house counsel, attorneys who work for statutory authorities, the appointment of subcommittees, publication of annual reports of the council, the issue of non-lawyers drafting legally prescribed documents such as pleadings, revocation of operational licenses, among others. Mr. Speaker, suffice it to say that on behalf of the government, I would like to thank all those who took the time to read and provided comments on the bill. Over the weekend, we also saw a document which has been produced by ALPA setting out their position on the bill. Might I say, Mr. Speaker, that although they, for whatever reasons, submitted their response long after the closing date for comments, we nevertheless took careful note of the comments. We note that they have set out in a more detailed way their repeated views about what the government is attempting to do via the bill. The new suggestion that government should jettison or defer the provisions in the bill dealing with the practice of Cayman law overseas until after the pandemic or some other indefinite time is, Mr. Speaker, one that government is unable to accede to. It is simply impractical to do so, and it serves no purpose whatsoever, when in fact one of the central issues of this exercise is the matter of the regulation of overseas practices that has been talked about for decades. Most of their other suggestions, Mr. Speaker, have been dealt with in the bill to the extent possible. Some, as I said earlier, will be more fully prescribed by the supporting regulations to the bill. But, Mr. Speaker, I wish to also thank them for their comments on the bill, and I'm confident that at the end of the day, their members will find that the bill seeks to otherwise strike a fair balance in the regulation of the profession. Mr. Speaker, if I may now speak to the individual clauses in the bill. The bill is arranged into 12 parts and contains 101 clauses. Part 1 contains clauses 1 and 2, which deal with preliminary matters. Clause 1 contains the short title and commencement provisions. Clause 2 provides definitions for words used throughout the legislation. Part 2 contains clauses 3 to 23, which provide for the establishment, functions, and powers of the Cayman Islands Legal Services Council. Clause 3 establishes the Council. Clause 4 provides for the constitution of the Council so that the Council consists of 4 members as follows: the Chief Justice, the Attorney General, a non-practicing attorney at law appointed by the Premier, and a non-practicing attorney at law appointed by the Leader of the Opposition. Mr. Speaker, I spoke earlier about the composition of the Council. A committee stage amendment will be laid to amend Clause 4 to provide for the appointments by the Premier and Leader of the Opposition to be made after consultation with the bodies representing the legal profession, and as I explained then, Mr. Speaker, to provide for the appointment of 3 practicing attorneys at law to the Council, 2 by the Premier and 1 by the Leader of the Opposition, so that the membership of the Council will be increased to 7. And as I indicated earlier, to address the very important concern expressed by the Chief Justice, that we will appoint, as well as non-practicing attorneys, 3 who are actually in active practice and therefore are able to bring a perspective and knowledge of the issues and concerns which the profession is experiencing at any given point. Mr. Speaker, Clause 5 provides for the Council's functions, which include A, to encourage and promote the upholding of the rule of law, B, to promote high standards of professional conduct by attorneys at law, C, to regulate the practice of law in the islands, D, to encourage and promote the study of law, E, to supervise legal education and practical legal training leading to local qualification for admission as an attorney at law, F, to establish or supervise a system of law reporting, G, to carry out the functions of the Council under the Proceeds of Crime Law 2020 revision in relation to attorneys at law, in accordance with the assignment of the Council as the supervisory authority under Section 4.9 of that law. And Mr. Speaker, the importance of that particular point is that this is one of the most serious issues that continue to trouble us when we are dealing with the international agencies such as the EU and the OECD and the FATF and those others, is that there is, in their view, still no truly effective means of regulating the attorneys, the legal profession in Cayman for the purposes of anti-money laundering and counter-terrorism financing concerns. So the Council will have this as one of its key functions. Mr. Speaker, to carry out such other functions as are imposed on the Council by this law or any other law. Mr. Speaker, Clause 5 also gives the Council the power to establish committees or subcommittees for the purposes of advising on or performing any of the Council's functions under this legislation or any other law. The committees may comprise members of the Council only, or members of the Council and persons who are not members of the Council. A committee stage amendment will be brought to Mr. Speaker to amend Clause 5 to remove requirement from the Council to seek the approval of Cabinet to establish the committees. Again, a concern pointed out by the Honourable Chief Justice that the Council, once it's appointed, should have the ability to operate independently without the need for Cabinet approval in relation to the execution of its functions. Mr. Speaker, the Council, this clause will also give the Council the power to delegate any number of its functions to subcommittees, because it is expected that the management of a profession as the size of the one in Cayman now and as complex and sophisticated as it is will require the efforts and the expertise of many more than just the seven proposed members of the Council. Mr. Speaker, Clause 6 gives the Council ancillary powers in relation to the carrying out of its functions. Clause 7 provides for the appointment and employment of a secretary to the council and such other public officers as the deputy governor, after consultation with the Attorney General, thinks are necessary for assisting the council in the proper performance of its functions under the law. Mr. Speaker, I mentioned earlier that the plan is for the council to be supported by a full-time secretariat funded out of the public purse. This clause speaks to that. So too does clause 19. A committee stage amendment will be laid to amend clause 7 to clarify that the secretary to the council would be a public officer. Mr. Speaker, clause 8 provides for an appointed member to hold office for 5 years on terms and conditions determined by the Premier or the Leader of the Opposition, as the case may be. An appointed member is eligible for reappointment for one additional period of 3 years. Clause 9 allows for acting appointments to be made where a member is absent or unable to act. Clause 10 permits an appointed member to resign from office by letter addressed to the Chief Justice. Clause 11 gives the Premier or Leader of the Opposition, as the case may be, the power to revoke the appointment of an appointed member after consulting the other members of the Council. Mr. Speaker, I would just interpose here that some concern has been raised by some with whom we consulted about what they perceived as political involvement in the affairs of the Council. And our response to them in this particular case, Mr. Speaker, which is how the Council is appointed, is simply this. Anyone who has a look at the Cayman Islands Constitution, Order 2009, as amended by the 2020 amendment, will see that the whole structure of the various of this part that deals with what I call the institutions supporting democracy, all of the various commissions that are established under that section, under that part of the Constitution, involve appointments done on the advice of the Premier and the Leader of the Opposition, including, Mr. Speaker, the Constitution Commission and the Judicial and Legal Services Commission. So the political role is limited to merely appointing members. Thereafter, that is the end of the political involvement. Someone, Mr. Speaker, has to make the appointments. And I can think of no better than, not because I hold the office temporarily, my term is coming to an end, but those who have been elected to the highest offices in the land and who are and remain always accountable to the people who elected them in the first place. Mr. Speaker, Clause 12 provides for the filling of a vacancy in the office of an appointed member. Clause 13 requires the clerk of the court to publish both in the Gazette and such other media as the clerk determines details of each appointment of a member, the resignation of an appointed member, and the revocation of the appointment of an appointed member. Clause 14 gives the Council the power to regulate its practice and procedures. Clause 15 provides for meetings of the Council. The Council has the power to co-opt any person whom it considers able to assist in its deliberations. Clause 16 protects members of the Council and members of committees of the Council from liability against claims, damages, costs, charges, or expenses resulting from the discharge or purported discharge of a function of the member as a member of the Council, where the claims, damages, costs, charges, or expenses are not caused by the bad faith of the member. Clause 17 requires a member of the Council to disclose the fact that the member has a conflict of interest in a matter before the Council. Clause 18 provides for an appointed member to be paid an allowance. Clause 19 provides for allowances and other administrative expenses paid or incurred by the Council or any committee or other person referred to in Section 5.3 in carrying out the functions of the Council to be paid out of the general revenue of the islands. Clause 20 requires the Council to keep proper accounts. Clause 21 requires the Council within 3 months of the start of each financial year to prepare and submit to the Cabinet an annual report on the manner in which the Council performs its functions during the preceding financial year. A committee stage amendment, Mr. Speaker, will be brought to amend Clause 21 to provide for the annual report to be published in the Gazette within the same 3 months. That is 3 months of the end of a financial year. Clause 22 gives the Chief Justice the power to assign to the clerk of the court such functions as the Chief Justice thinks necessary for the proper carrying out by the Council of its functions. Clause 23 provides for the seal of the Council to be authenticated by the Chief Justice and for a document of the Council not on the seal to be executed by an officer of the Council appointed to do so. Mr. Speaker, Part 3 contains clauses 24 to 28, which make provision for the practice of Cayman Islands law. Clause 24 prohibits a person from practicing Cayman Islands law in the islands or in another jurisdiction except as provided in the legislation. A person practices Cayman Islands law if for or in the expectation of gain or reward the person provides or holds himself or herself out as providing legal services in respect of Cayman Islands law or in the islands. A committee stage amendment will be brought to amend Clause 24 to clarify the types of services that are not considered legal services. Clause 24 also provides that a person practices Cayman Islands law if for or in expectation of gain or reward the person provides legal services in respect of Cayman Islands law or in the Cayman Islands. A person also practices Cayman Islands law if the person holds himself or herself out as qualified to provide legal services for gain or reward. The circumstances in which a person is not to be taken as practicing Cayman Islands law are also set out in Clause 24. Clause 25 permits an attorney at law who holds a practicing certificate to practice Cayman Islands law subject to compliance with the legislation. The practice of Cayman Islands law by an attorney at law in another jurisdiction with an affiliate is also subject to compliance with the law of that jurisdiction. Clause 26 permits a recognized law entity to practice Cayman Islands law in the islands subject to compliance with the legislation. The practice of Cayman Islands law by a recognized law entity in another jurisdiction with an affiliate is also subject to compliance with the law of that jurisdiction. Clause 27 provides exemptions from the law in respect of the rights in connection with the duties of the offices of the Attorney General or the Director of Public Prosecutions to act as an advocate or the privileges of the Attorney General or Director of Public Prosecutions. Clause 28 provides an exemption from Part 3 for a person, whether or not an attorney at law, who has statutory authority to practice Cayman Islands law. Clause 28 also provides that nothing in Part 3 prohibits an attorney at law from establishing that attorney at law as a law firm or as a member or partner of a law firm, except that A, in the case of a law firm that is an attorney at law practicing Cayman Islands law in the Cayman Islands as a sole practitioner, the attorney at law must be a Caymanian. Again, Mr. Speaker, that is fixing an issue which currently exists where anyone who meets the requirements of being qualified to practice in the Cayman Islands is able to come here and get a work permit and set up an operation without any Caymanian involvement in the firm. In the case B, in the case of a law firm that is a partnership practicing Cayman Islands law, at least one partner of the partnership must be an attorney at law who is Caymanian. And again, Mr. Speaker, there is no requirement currently that there needs to be any Caymanian partner in any law firm. Or C, in the case of a law firm that is a recognized law entity, at least one member or partner of the recognized law entity must be an attorney at law who is Caymanian. The same point again, Mr. Speaker. Mr. Speaker, again, there are those who have mused aloud about why at least one member or partner of a law firm must be a Caymanian. As I said, Mr. Speaker, there is no such requirement at the moment. So this has to be seen as important. In addition, I am verily advised, Mr. Speaker, that the majority of law firms in these islands already meet that requirement. So again, Mr. Speaker, we do need some perspective here. The practice of law is a business where people invest their capital and would understandably wish to have some latitude about who should manage their business. Mr. Speaker, Part 4 contains clauses 29 to 36, which make provision for admission of an attorney at law. Clause 29 gives the judge the power to admit a person as an attorney at law. A judge must not admit a person as an attorney at law unless he or she is satisfied that the person meets the eligibility criteria set out in that provision, including specific personal qualifications and professional qualifications. Clause 30 sets out the personal qualifications required for admission as an attorney at law, so that to be admitted, a person must A, be a Caymanian, B, hold a work permit, or a residence and employment rights certificate, or otherwise be entitled under the Immigration Transition Law 2018 to reside and work in the islands as an attorney at law in the capacity in which the person is or is to be employed. C, be employed by the government, or D, be ordinarily resident in another jurisdiction and be a partner, director, member, employee, associate, or consultant of a law firm or an affiliate of a law firm. Mr. Speaker, a committee stage amendment will be laid to amend Clause 30 to permit a person who is employed by a statutory authority to qualify for admission as an attorney at law as well. Clause 31 requires that to be admitted as an attorney at law, a person must satisfy a judge that the person is not an undischarged bankrupt, has not engaged in conduct which would constitute an act of professional misconduct under the law, and is not disbarred for professional misconduct from practicing law in another jurisdiction. Clause 32 sets out the professional qualifications required for admission as an attorney at law, including local and foreign qualifications. Clause 33 requires a person to have had at least 5 years post-qualification experience in the practice of law in another jurisdiction in order to be admitted as an attorney at law by virtue of a foreign qualification. The person must also be in good standing on a register or its equivalent maintained by a court or other relevant body of the relevant jurisdiction that contains the name of each person entitled to practice law in that jurisdiction. The post-qualification experience requirements do not apply if the person is a Caymanian or the holder of a residency and employment rights certificate. Clause 34 provides for an application for admission to be made by motion to the court and provides for a prescribed admission fee and documentary evidence to be submitted in support of the application. Clause 35 provides for an application to be made to a judge to permit a person to come to the islands to carry out the functions of an attorney at law in a particular suit or matter. The application must be made by a law firm. Mr. Speaker, this arrangement currently exists in the legal practitioners law, where attorneys can come here and be admitted to deal with a particular case. Mr. Speaker, under the old law, it was referred to as limited admission. Mr. Speaker, Part 5 contains clauses 36 to 47, which provide for matters relating to attorneys at law. Clause 36 provides that an attorney at law is an officer of the court. Clause 36 also prohibits an attorney at law from appearing on behalf of another person in a court, tribunal, or inquiry in the islands if the attorney at law holds a practice certificate that only authorizes the attorney at law to practice Cayman Islands law in another jurisdiction. Again, Mr. Speaker, I pause here to say this is an important point. So if you are employed on the basis of practicing Cayman Islands law in another jurisdiction, in one of the affiliate firms, unless you are Caymanian, you simply cannot come here to appear before our court. However, the prohibition does not apply to an attorney at law who is a Caymanian. This again, Mr. Speaker, speaks to control over those who are only eligible to practice Cayman Islands law overseas. Clause 37 requires an attorney at law or recognized law entity to comply with an obligation imposed on the attorney at law or recognized law entity under the law, and a failure to comply with an obligation amounts to professional misconduct and accordingly may be the subject of disciplinary proceedings. Clause 37 also requires that a code of professional conduct is issued for attorneys at law and recognized law entities. A committee stage amendment will be laid to amend Clause 37.3 to require the Council, rather than Cabinet, as the current bill provides, to issue the code after consultation with the legal profession. An attorney at law or recognized law entity is required to observe the code. Clause 37.5 makes provision in respect of a failure to comply with that requirement. A committee stage amendment will be laid to amend Clause 37.5 to provide that such a failure may amount to professional misconduct, and that any such failure may, in disciplinary proceedings in relation to the attorney at law or recognized law entity, be relied upon as evidence to establish professional misconduct by the attorney at law or recognized law entity. Clause 38 requires the clerk of the court to keep a register to be known as the court roll in respect of each person admitted for the time being to practice as an attorney at law. A committee stage amendment will be laid to amend Clause 38 to provide for the jurisdiction in which the person practices Cayman Islands law to be added to the list of information that will be entered on the roll. Clause 39 requires the clerk of the court to keep the roll and documents relating to it at the court, and to permit a person to inspect the roll free of charge if the office of the court is open. Clause 40 provides for the grant of a certificate of enrollment upon the name of a person being entered in the roll. The certificate of enrollment is granted under the seal of the court and must be signed by the clerk of the court. Clause 41 provides for the alteration in enrollment details of an attorney at law. Clause 42 permits the voluntary removal from the roll of an attorney at law upon application to the clerk of the court. Clause 43 provides for the removal of the name of an attorney at law from the roll for non-practice. A committee stage amendment will be laid to amend Clause 43 so that the name of a Caymanian would not be removed from the roll for non-practice, and to allow 12 months rather than 3 months for non-Caymanian attorneys to object to the removal of their names for non-practice. The committee stage amendment would extend Clause 43 to apply to in-house counsel. The committee stage amendment will also provide for in-house counsel the definition to also mean an attorney at law who solely provides legal services to the attorney at law's employer, including a statutory authority that is an employer, or to other entities that are part of the same group of entities as the employer. Clause 44 provides for the keeping on the roll of the name of attorneys at law who do not wish to practice Cayman Islands law, but wish to keep their name on the roll. A committee stage amendment will be laid to amend Clause 44 as a consequence of the amendments made to Clause 43, and also to require an attorney at law applying to keep the attorney at law's name on the roll to state whether or not the attorney at law is or has been the subject of a disciplinary complaint or any other action that could cause or did cause the attorney at law's name to be struck off the roll of a jurisdiction in which the attorney at law is or was admitted. The attorney at law would therefore also be required to include criminal convictions in the statement. Clause 45 imposes an obligation on a law firm to inform the clerk of the court if a law firm or an affiliate of a law firm ceases to employ in another jurisdiction an attorney at law who is not a Caymanian. The managers of the law firm must ensure that the law firm complies with the obligation. If a law firm fails to comply with the obligation, each manager of the firm commits an offense and is liable on summary conviction to a fine of $5,000. Clause 46 gives an attorney at law the power to administer oaths. Clause 47 gives an attorney at law and a recognized law entity the power to sue for fees and costs. Mr. Speaker, Part 6 contains clauses 48 to 52, which provide for practicing certificates. Clause 48 prohibits an attorney at law from practicing Cayman Islands law in the islands unless the attorney at law holds a practicing certificate that authorizes the attorney at law to practice Cayman Islands law, principally in the islands. Clause 48 also prohibits an attorney at law from practicing Cayman Islands law in another jurisdiction unless the attorney at law holds a practicing certificate that authorizes the attorney at law to practice Cayman Islands law, principally in another jurisdiction. Clause 49 provides for an attorney at law to obtain a practicing certificate on application to the council and payment of the prescribed practicing certificate fee. A committee stage amendment will be laid to amend Clause 49 to allow an in-house counsel to make an application for a practicing certificate. The committee stage amendment will also require that a statement be made in the application for a practicing certificate regarding actions taken against an attorney at law. Clause 50 provides for the council to issue a practicing certificate. The council is required to issue and publish guidance on matters that the council must have regard to in issuing a practicing certificate, including A, the number of practicing certificates that are in issue to attorneys at law practicing Cayman Islands law in another jurisdiction with affiliates of the law firm, and B, the compliance by the attorney at law with any applicable program of legal education and practical legal training that will be undertaken in the attorney at law's principal place of practice during the currency of the practicing certificate. C, the jurisdiction that will be the attorney at law's principal place of practice during the currency of the practicing certificate. And D, compliance by the law firm, its affiliates, and the attorney at law with this law and regulations made under this law. Clause 50 provides that the council shall not issue a practicing certificate that authorizes an attorney at law to practice Cayman Islands law in another jurisdiction if the total number of attorneys at law practicing in all other jurisdictions with affiliates of the law firm would exceed the number of attorneys at law practicing in the islands with the law firm. This, Mr. Speaker, is the one-to-one ratio principle which has been embedded in the legislation, that the number of lawyers practicing in all other jurisdictions in affiliate offices of a Cayman Islands law firm must not exceed the number who practice in the Cayman Islands. Clause 50 also provides that the council must not issue a practice certificate that authorizes an attorney at law to practice Cayman Islands law in another jurisdiction unless the attorney at law swears the prescribed oath or makes the prescribed affirmation. Further, a practicing certificate must be in a form approved by the council and is valid from the date of its issue and expires on the 31st of January of the ensuing year, unless before that date the practicing certificate becomes void. Clause 51 provides for a practicing certificate issued to an attorney at law to become void in certain circumstances. A committee stage amendment will be laid to amend Clause 51 to extend it to include practicing certificates issued to in-house counsel. Clause 52 requires the counsel to publish details of practicing certificates. Mr. Speaker, Part 7 contains clauses 53 to 62, which provide for the recognition of a company or limited liability partnership as a recognized law entity. A committee stage amendment will be laid to amend the provisions in Part 7 to include a partnership as an entity that may be recognized as a recognized law entity. Clause 53 provides for applications for recognition as a recognized law entity. Clause 54 gives the Council the power to recognize a company or limited liability partnership as a recognized law entity, if the Council is satisfied that the company or limited liability partnership complies with Clause 28(2)(c) and is otherwise satisfied that the company or limited liability partnership is a suitable body to practice Cayman Islands law. A committee stage amendment will be laid to extend Clause 54 to extend the Council's power of recognition to a partnership. Clause 55 provides for the issue of a certificate of recognition upon recognition as a recognized law entity. Clause 56 provides for appeals against refusal of recognition. Clause 57 requires a recognized law entity within 60 days after a change in its directors, managers, members, or partners to notify the Council of the change. Clause 58 restricts a recognized law entity from carrying on any business other than the practice of Cayman Islands law in the Cayman Islands. However, a recognized law entity may, with the approval of the Council, carry on a business associated with its practice of Cayman Islands law. A recognized law entity that fails to comply with the restriction ceases to be a recognized law entity. Clause 59 permits a recognized law entity to carry on business under a name that does not include the word limited or the abbreviation LTD if it holds itself out to be a recognized law entity. Clause 60 provides that a recognized law entity ceases to be a recognized law entity if a winding up order under the Companies Law 2020 revision or the Limited Liability Partnership Law 2017 is made in respect of it. Clause 61 makes each director, manager, or member of a company or limited liability partnership who is an attorney at law guilty of professional misconduct if the company or limited liability partnership ceases to be a recognized law entity but continues to practice Cayman Islands law. As soon as practicable, after the Council becomes aware that a company or limited liability partnership has ceased to be a recognized law entity, the Council must publish the name of the company or limited liability partnership and the fact that it has ceased to be a recognized law entity. The committee stage amendment will amend Clause 61 to extend the provision to partners of partnerships. Clause 62 makes it an offense for a person to falsely claim to be a recognized law entity. Part 8 contains clauses 63 to 66, which provide for matters in respect of law firms. Clause 63 makes it a criminal offense for an attorney at law to practice Cayman Islands law in another jurisdiction otherwise than with a law firm or with an affiliate of a law firm. The punishment for the offense is a fine of $50,000 or imprisonment for a term of 2 years, or both. Clause 64 requires the law firm to have an annual operational license to practice Cayman Islands law. A committee stage amendment will be laid to amend Clause 64 to provide for the application for the annual operational license to be made to the Council and to give the Council the power to suspend or revoke an annual operational license where a law firm breaches a provision of this law or regulations made under this law. Clause 65 gives the Cabinet the power, after consultation with the Council, to make regulations requiring law firms to secure insurance for a prescribed minimum amount of cover against losses arising from claims in respect of civil liabilities incurred by such law firms in the practice of Cayman Islands law, and any business associated with the practice of Cayman Islands law permitted under the law. A committee stage amendment will be laid to amend Clause 65 to impose a requirement for the Cabinet to make the regulations. Clause 66 requires a law firm on or before the 31st of January in each year to deliver to the Council a certificate indicating whether or not the law firm has, during the previous year, complied with each obligation imposed on the law firm by the law, and where the law firm is a recognized law entity, complied with the criteria to maintain its status as a recognized law entity. The annual compliance certificate must be signed by a manager of the law firm. If a law firm fails to comply with the requirement of this provision, each manager of the firm commits an offense and is liable on summary conviction to a fine of $5,000. Part 9 contains clauses 67 to 70, which deal with legal education and practical legal training for local qualification for enrollment of an attorney at law. Clause 67 gives the Council the power to designate a legal educator as a recognized legal educator if the Council is satisfied that it has the facilities required to provide legal education or practical legal training to a standard required by Part 9. Clause 68 gives the Council the power to make arrangements for the provision of a system of legal education and practical legal training leading to local qualification for enrollment as an attorney at law. The Cabinet is given the power, after consultation with the Council, to make regulations relating to matters connected with the Council's functions under Clause 68(1). Clause 68 also gives the Council the power to make arrangements requiring a person admitted as an attorney at law to participate in a program of legal education or practical legal training. The Cabinet is given the power, after consultation with the Council, to make regulations relating to matters connected to the Council's functions under Clause 68(1) and 68(2). Clause 69 provides for regulations in respect of qualifying as an attorney at law. Clause 70 provides for regulations to be made in respect of a program of legal education or practical legal training. Mr. Speaker, Part 10 contains clauses 71 to 80, which provide for matters in respect of articles of clerkship. Clause 71 gives the Cabinet the power, after consultation with Council, to make regulations in respect of service under articles of clerkship. Clause 72 specifies the qualifications required for an attorney at law to take an article clerk into the attorney at law's service. Clause 73 gives a recognized law entity permission to take an article clerk into the service of the recognized law entity. Clause 74 gives the Attorney General, Director of Public Prosecutions, and Clerk of the Court permission to take an article clerk into their respective service. Clause 75 gives the Council the power to certify that time spent by a person in a legal or judicial department of the public service performing duties is equivalent to a similar time spent in the service of an attorney at law under articles of clerkship. Clause 76 gives the Council the power to discharge articles of clerkship in certain circumstances. Clause 77 provides for the transfer of articles of clerkship. Clause 78 sets out the obligations of an attorney at law or a recognized law entity in relation to an article clerk. Mr. Speaker, Part 11 contains clauses 79 to 95, which provide for the investigation of alleged misconduct by an attorney at law. A committee stage amendment will be laid to amend the provisions in Part 11 to introduce an independent disciplinary tribunal to hear complaints of alleged professional misconduct by an attorney at law. Clause 79 exempts from the application of Part 11 any conduct of a person while holding or acting in an office to which Section 106 of the Constitution applies. Clause 80 permits a person to file with the Council a complaint that any specified conduct of an attorney at law constitutes professional misconduct by the attorney at law. Clause 81 imposes a duty on the council to investigate a complaint. Clause 82 requires the council to make and publish rules in respect of the process for its investigation of the conduct of attorneys at law. Clause 83 gives the council the power to do everything reasonably necessary to investigate any conduct of an attorney at law that is alleged to constitute professional misconduct. Committee stage amendments will be laid to delete and substitute clauses 81, 82, and 83, so that while the council would remain responsible for investigating complaints alleging misconduct, and an independent legal services disciplinary tribunal would be established and would be charged with the responsibility for hearing and determining the complaints of alleged professional misconduct by attorneys at law and imposing disciplinary sanctions. And so, Mr. Speaker, the purpose of these particular committee stage amendments is to ensure that we don't wind up with a situation where the same body which is receiving the complaints, carrying out the investigations, and prosecuting the case winds up also deciding whether or not the individual concerned is guilty of whatever they have been charged with. So this will set up an independent legal services disciplinary tribunal, which it is proposed, and these will come in the regulations, will be chaired by a retired judge. Clause 84 provides disciplinary sanctions for professional misconduct by an attorney at law. A committee stage amendment will be laid to amend Clause 84 to provide for the disciplinary tribunal to impose disciplinary sanctions. Clause 85 requires the publication of a striking off and suspension from practice of an attorney at law to be published. Clause 86 gives the council the power to make an interim order to suspend from practice an attorney at law being investigated by the council until the investigation has been completed and any subsequent order made by the council under Clause 86 has come into effect. In light of the changes being proposed to give the disciplinary tribunal, rather than the council, the responsibility for hearing complaints, a committee stage amendment will be laid to give the court, rather than the council, the power to make an interim order. Clause 87 provides for the restoration of the name of an attorney at law to the roll. Clause 88 provides for the termination of suspension of an attorney at law. Clause 89 provides for the form and proof of an order. Clause 90 requires certain orders of the council to be filed with the clerk of the court. Clause 91 provides for a fine or payment of costs imposed to have effect as if it were a debt due to the general revenue of the islands. Clause 92 entitles an attorney at law to appeal to the Court of Appeal against a disciplinary sanction. Clause 93 provides for the notification of the suspension or striking off of an attorney at law to parties related to a trusteeship held by the attorney at law. Clause 94 makes an attorney at law guilty of professional misconduct if the attorney at law practices law in contravention of a condition or restriction specified in the attorney at law's practicing certificate. Clause 95 requires that if when investigating the conduct of an attorney at law, it appears to the council that the attorney at law or any other person may have committed an offense, the council must refer the matter to the police. Mr. Speaker, Part 12 contains clauses 96 to 101, which are miscellaneous provisions. Clause 96 provides for practice in the islands of the law of another jurisdiction. Clause 97 makes it an offense to knowingly or willfully provide false or misleading information in an application, notification, notice, or filing under the legislation. The punishment for such an offense is a fine of $10,000 or imprisonment for a term of 5 years or both. Clause 98 provides for the liability of partners of officers of a limited liability partnership or officers of a body corporate where an offense is committed by the limited liability partnership or the body corporate. Clause 99 gives Cabinet the power, after consultation with the Council, to make regulations prescribing anything that may be prescribed under the law, providing for access to the legal profession and training and development of attorneys at law, or providing for such matters as may be necessary or convenient for carrying out or giving effect to the legislation and its administration. Clause 100 repeals the Legal Practitioners Law 2015 revision and saves the Legal Practitioners Students Regulations 2018 revision. Clause 101 gives the Cabinet the power to make regulations to provide for such savings, transitional and consequential provisions to have effect in connection with the coming into force of any provision of this law as are necessary or expedient. The regulations may be given retrospective operation to a day not earlier than the day that the law comes into force. And that, Mr. Speaker, concludes my explanation of the 101 clauses contained in this bill. I hope, Mr. Speaker, that the House has found that helpful. Mr. Speaker, we have heard discussions about outsourcing of the practice of Cayman law overseas. But we have no empirical evidence that remotely supports the suggestions that the practice of Cayman law overseas has resulted in a decline in the growth of the practice of law here at home. Indeed, Mr. Speaker, the evidence points in the opposite direction. We do not need data to confirm that since the establishment of the first overseas office in Hong Kong in 1995, Cayman has seen exponential growth in the number of law firms that have opened here in Cayman. It is obvious to the naked eye. As you would say, Mr. Speaker, blind Bartimaeus would notice it. By way of illustration, Mr. Speaker, in 1995, when the first Cayman office was opened in Hong Kong, the first office of a law firm, a Cayman law firm, Cayman had only 2 international law firms. There were only 163 attorneys on the roll in Cayman. 163, Mr. Speaker. I think I was 65 or 67. Yeah. Today, Mr. Speaker, there are at least 15 international law firms in Cayman. And the number of attorneys on the roll has increased from 163 in 1995 to somewhere around 900. Not to mention, Mr. Speaker, that this has resulted in the employment of hundreds more persons in these firms and their support services within the legal sector. So, Mr. Speaker, with all of the rhetoric and all of the rubbish that you hear on the talk shows about how this legislation is going to undermine the future of the profession, of the industry, it is going to trammel on the opportunities of Caymanians in the legal profession. The clear evidence is that the legal services business in Cayman has flourished and continues to do so, notwithstanding the provision of services involving Cayman law overseas. In fact, Mr. Speaker, I'll put it the other way. It is precisely because of the establishment of the overseas offices that Cayman's legal profession, but not just the legal profession, the entire financial services industry has flourished beyond the wildest imagination, belief, hopes, dreams, aspirations of anyone. Mr. Speaker, the member from Bordentown West is absolutely right in his analogy of the lawyers being the hunters and the rest being the gatherers. It is the law firms that seek out the business and funnel it to Cayman. And anyone who does not grasp that and appreciate that is supremely unqualified to criticize what transpires here and what this bill is seeking to undergird and to ensure continues. The continued prosperity of the financial services industry and the continued creation of opportunities, lucrative opportunities for our people. They cannot, Mr. Speaker, live in their insular little bubble because they practice only a certain type of law and criticize the success of other firms and other attorneys who choose to do another type of law. Mr. Speaker, the stage is big enough for everybody. The pie is big enough for everybody. Do not try to hold back the continued development of the profession and the industry. Do not try to slam doors on the opportunities for your own people because you envy where other people have gotten to. Mr. Speaker, I'm not asking about this. I know the people of whom I speak, the lawyers of whom I speak. And Mr. Speaker, I was not one of those who practiced any of this overseas type of work. I was a in the trenches litigation lawyer. But if I had hung around there for the last 20 years instead of going into public life, I'm sure I would have done what my good friend David Rich has done, because a better Caymanian litigation lawyer has yet to be found than David Rich was. You think he does any of it? He hasn't done any of it in 25 years. None do me. So, Mr. Speaker, the clear evidence is that the legal services business in Cayman has flourished and continues to do so precisely because of the range and quality of services that we provide, including involving the practice of Cayman law overseas. It follows, Mr. Speaker, that there is a concomitant benefit to the financial services sector in these islands. This, Mr. Speaker, is because there is, among other things, a resultant increase in the amount of companies incorporated here because of overseas practitioners. I am advised that the percentage ranges from 30 to 40% more companies on the register. Mr. Speaker, all of these companies have to pay an annual as well as other fees. By way of example, I am advised that a typical SEMA-regulated fund established by a practitioner overseas will generate local annual fees, local director licensing fees, annual SEMA registration fees, registered office service fees, audit fees, and fiduciary service fees for local directors. There are also fees that are paid annually to persons, to entities, and to government directly. And Mr. Speaker, at the end of 2019, last year, approximately 56% of all companies issued on the Hong Kong Stock Exchange main board were Cayman companies. In the same vein, Cayman companies accounted for more than 70% of all companies listed on the Hong Kong Stock Exchange Growth Enterprise Market Board, or GEM board. Mr. Speaker, I want that to sink in for a moment. Do we really believe that any of that would have occurred had Cayman law firms simply limited their operations and their practices to the work that existed in the early days? Mr. Speaker, the benefit to the Cayman economy is obvious. Something I know the member from Bontown West would readily agree with. It is all made possible, Mr. Speaker, primarily because of the dominance of the Cayman Islands' presence in the overseas space, which is enhanced by the positioning of the affiliated offices. Cayman law, and we should be proud of this instead of talking it down on the talk shows, beating down our own image and jurisdiction while claiming to fly the Cayman flag like some kind of patriots. Cayman law and legal services is now a global product that is eagerly sought after. We should be proud of it. We should be having parades about it. But what do? Some of us go hammer it, hammer it, hammer it. Shut down all of the law firms overseas because they're taking away work from Caymanians. Really? Mr. Speaker, I am alive to the obvious questions that will flow from what I have just articulated. So, Mr. Speaker, let me, for completeness, explain how this bill and the supporting regulations will ensure that this overseas practice continues to be of optimum benefit to Cayman. It does so by stipulating that the Cayman law footprint within Cayman is always larger than the overseas practice collectively. Hence, the ratio. It requires that attorneys overseas must be subject to the same admission requirement as attorneys locally and must be subject to the same regulatory oversight. It ensures that the office in Cayman is legally responsible and accountable for the overseas practitioners. It requires that Cayman legal services can only be provided overseas by firms that have a presence and have invested locally here in Cayman. And that is not currently the case, Mr. Speaker. There are, I don't know how many, but there are still reports being received of persons who have no connection to these islands who purport to practice Cayman law overseas. There is nothing we can do about it because there is no legislation that prohibits it. And finally, Mr. Speaker, the bill and supporting regulations guarantee that overseas offices will benefit young Caymanian, they don't have to be so young, but Caymanian attorneys by requiring law firms to first advertise overseas job opportunities within the Cayman office and give Cayman attorneys the first opportunity to apply for those postings. None of that exists now, Mr. Speaker. None of it. But those who have this blind obsession with ensuring that Cayman stays where it was in 1969 would urge members of this House to speak against this bill, to speak against provisions which will give Cayman attorneys the first opportunity to apply for postings in law offices, affiliate offices overseas. That is but one, Mr. Speaker, of the many protections provided in this bill to ensure that Caymanians get greater opportunities of sharing in the huge and most lucrative law practices that exist. But as I said, Mr. Speaker, they will get on the radio and they will urge members of this House to say that this is not a good thing, that we should not proceed with this legislation because this is hurting Caymanians seriously. Mr. Speaker, for the benefit of the Leader of the Opposition in particular, I want to read that provision again. And finally, the bill and supporting regulations guarantee that overseas offices will benefit Caymanian attorneys by requiring law firms to first advertise overseas job opportunities within the Cayman office and give Cayman attorneys the first opportunity to apply for those postings. This ensures that the overseas practice is working for the benefit and guarantees the continuing professional development of our Caymanian attorneys. Mr. Speaker, this list that I just went through is not exhaustive, but what it does is speak to the undeniable fact that it is a massive improvement on what we have now, which is the sum total of nothing in terms of regulatory frameworks for these offices, absolutely nothing by way of guarantees for the professional development of Caymanian attorneys. And Mr. Speaker, this bill is a solid platform on which to strengthen our initiative to ensure that not only do we have a modern piece of legislation that regulates and governs the operation of legal practices in these islands, but that it also provides for the first time ever a legal basis to ensure that Caymanians, in a detailed way, that the immigration law has not even come close to, that Caymanian attorneys have every opportunity at professional development and every opportunity of upward mobility within the law firms, not just in Cayman, but the affiliate offices overseas. Mr. Speaker, this concludes my presentation of the proposed bill, and I commend it to this Parliament. As I've indicated, there are committee stage amendments to be made to the bill arising from the public consultations and indeed from our own reflection on this side. In closing, I want to record the government's most grateful thanks to the learned Attorney General and his team, including Ms. Karen Stephen Dalton, members of the legal profession, other members of the business sector, my cabinet, my caucus, the Honorable Chief Justice and the other members of the judiciary, my own staff in the Office of the Premier, and all those who took time to meet and respond to us, including the Honorable Leader of the Opposition and other members of the Opposition. Mr. Speaker, this is a joined-up effort, all for love and for the good of this country, that we all love so much. All of us, Mr. Speaker, whatever our views are about these matters, I know that all members of this House love this country dearly and love our people just as much. And so, Mr. Speaker, I do hope that when all the speeches are made and the vote is taken, we do what we all know best will be in the best interest of this country and of our people, and in particular, Mr. Speaker, of our young people.
Does any other member wish to speak? The Honorable, the Leader of the Opposition.
Mr. Speaker, I thank you for your recognition of me. Mr. Speaker, I want to start with my contribution to this 20-year-old piece of legislation that has gone through at least 15 iterations, at least. I want to start with the end of my, I better don't say that, but the end of the Premier's contribution and presentation of this bill. Mr. Speaker, I don't know what you were rowing about, because he and I are on the same page. Despite his and the Attorney General's inability to meet with me for any length of time, the opposition is Mr. Speaker, the Premier said that that's not true. I am not trying to row here. Mr. Speaker, the Attorney General called me months and months ago and asked if I was amenable to having a select committee to do this through. And Mr. Speaker, you know me, I love select committees to do these things. Subsequently, I called him and asked him what happened to it, and he said, well, we're not going to do it in that manner. That's what I'm talking about. Then, subsequent to that again, the Attorney General wanted to, said he had a bill. So I said, well, what about the committee? He said, well, we did a bill inside, which was somewhat of a surprise to me. But then we were supposed to meet, couldn't meet. Then the AG made arrangements for me and him to meet, and I responded and agreed to meet, because they first wanted to meet with me and then, if necessary, meet with all the opposition. And there was communication problems with that. They didn't tell me where it was. And then we, after that, met. But the Premier had other engagements as well, so he had to leave. So that's what I'm talking about. I'm not blaming them. I'm just saying, despite them not being able to meet with me, we are in agreement that this needs to be done. Of course, Mr. Speaker, we are at a different page on how it should be done. That is, the contents of the law, the bill, as to how we arrive at what is needed, in the words of the Premier, to protect Caymanians and promote Caymanians. Because, Mr. Speaker, I recall in 2010, after engaging myself fully in this for like almost 10 years then, your good self called a meeting at Associated Industries, I think it was, with legislators and the stakeholders and whatnot. And therein I said to everybody, we know how many of your partners we have made Caymanians. The question is, how many Caymanians have become partners? That question is yet to be answered. Now, Mr. Speaker, that is my objective here today and has always been, for the greater benefit of the people of this country. And I want the Premier to know, and all and sundry to know, that I don't envy anyone, especially Caymanians, who get more than I do. That's not part of my life. So he can take that out of his vocabulary. I don't need to be a part of that. And I am not a part of that, Mr. Speaker. Mr. Speaker, he spoke quite passionately about his good friend, David Rich, about his successes. Mr. Speaker, despite David Rich's successes, I said, why, if he was such a litigation attorney that we all know he was, came on black bread and raised in the streets of East 10, bred and born, bred in Cayman, raised in the streets of East 10. Why couldn't he be made a QC? Because everybody ties it up for them as opposed to us. And Mr. Speaker, to that end, may I say that there are young Caymanians coming up now who are as good as David Rich, a litigation attorney, and may I say, might be even better. Mr. Speaker, as I speak, I stare one in the face who sits in this gallery now. What is he to do? Stand on his head in Hero Square and beg to be made a QC? Is that what this is about? And Mr. Speaker, I speak of Barton. Okay? Let me call his name Richard Barton, in the interest of transparency. That's all I have ever wanted with a legal services law. I want Caymanians to benefit. I want us, the law firms in this country, to be homegrown. I want them to understand that I may not break bread with them, nor may I drink tea with them, but I understand their value. But I want them to understand, them and the Premier and all and sundry, that my objective here is to ensure, since you're operating here, that more Caymanians benefit as a result. That's all I want. I don't want anything else. I know the opportunity for me to be a lawyer has come and gone. That is, if it was ever there, if I was ever capable of doing that. Mr. Speaker, but there are many dogs in this fight that I have. I want it to be known that in the interest of transparency, let me say that my youngest son is now in law school, and not this one. He has had to do it overseas by distance learning because he was not good enough to go to this law school. Or so it appears like. So I leave that there so that, but to know that, everyone to know that my advocacy on behalf of the legal fraternity did not start because my son started this a year ago. I just want that to be known. Mr. Speaker, I agree with the Premier. Let's not slam the door on others because we are envious of those who did better than us. But my argument and my advocacy here today is let's open the door wider for more Caymanians' participation. That's all. I don't want anything more. Mr. Speaker, I agree with the Premier that the pie is big enough, but he will also agree with me when he says the pie is big enough for all to participate. He will also agree with me that all has not been participating. Yeah, that's why we need the law. But he also talked about, Mr. Speaker, of outsourcing, because I know he was sending a bullet across my bow. Because I was one of the first, not the first, but one of the first who termed it outsourcing. And I was told by many that there was no such thing. Yet, here we are today, we're using it. Outsource. Mr. Speaker, whilst I will agree with the Premier that this outsourcing has been a contention from day one, Mr. Speaker, there are those who says it has been illegal, and we are now legitimizing an illegal activity. And we have turned a blind eye to that. I hope the Premier and this country understands that I may have had a come to Jesus moment, in that there was a time when I said I would not support outsourcing of the Cayman Islands law. I believe I said that here on this floor many times. or at least a few times. I have had to come to terms with the fact that this is necessary. Conversion on the way to Damascus, you say? Maybe some of you need to walk on that road to Damascus in other matters. Mr. Speaker, Mr. Speaker, that's true. The Premier said conversion is not unique to the Apostle Paul. Well, I hope he follows in my footstep now too. And make sure it's not unique to me even. Anyway, Mr. Speaker, I understand. But if we must look back at the last 20 years, we have been lied to so often about this matter. At first they say it was a window dressing so that they could direct people here, direct business. You just need them there to be there. And Mr. Speaker, many of my colleagues will not know about this, but there are some of us who do. That's how it started. Then they say it was not within our territory, therefore we had no control over it. Mr. Speaker, if there had been Mandela thing, truth and reconciliation many years ago, we would have been okay today. Mr. Speaker, this bill, the Legal Practitioners Bill, amendments or new bill, came to this Honorable House in 2016. The reason that failed then was because there was no budget on it. The then Minister, Patton, refused to give. Mr. Speaker, I believe we all remember that that if there's anything I have is paperwork. Mr. Speaker, let me talk about the 9 things that we agreed to at that time. Well, 8. Mr. Speaker, you were there, sir, in that room. In that committee room. Number one, all firms must meet the requirements of 60-40 Caymanian ownership. Those who don't meet now can have an LCCL type of interim accommodation. Remove the concept of qualified firms. Any changes in ownership must be reported to the council. At that time, the council was made up of the lawyers, not the Chief Justice, and I'll come to that later on, Mr. Speaker. Number 2, council must be truly independent and 100% Caymanian. Could be appointed by cabinet. No more member per firm, and must include 1 sole practitioner. To match all current regulatory bodies which are appointed by cabinet.
Honorable member, we have reached the hour of 4:30. I'll call on the Premier to suspension of standing orders.
Thank you, Mr. Speaker. Mr. Speaker, I move the suspension of Standing Order 10-2 in order that the Honorable Leader of the Opposition may continue his good speech beyond the hour of interruption.
Question is that standing orders 10-2 be suspended in order to conduct business after the hour of 4:30. All those in favor, please say aye. Those against, the ayes have it. The House will continue after the hour of 4:30 p.m. The Honorable Leader of the Opposition continuing.
Thank you, Mr. Speaker. I don't know what he'll say when I'm through with when I've concluded. He'll row. But, Mr. Speaker, number 3 on that list of things we agreed to that night, which went way into the morning, was full and frank disclosure of overseas practitioners. To get a practicing certificate the firms and attorney must provide evidence to the regulatory body that they have legal authority to practice within the foreign jurisdiction, both from the firm and the attorney. The LCCL exemptions are subject to a written undertaking by each firm that full disclosure of overseas practices will be provided. 4, no grandfathering in of previous unqualified overseas practitioners. 5, training and advancement of Caymanians overseas practitioners are to pay in attention to practicing certificates a fee equivalent to the relevant work permit fee, which would be applicable in the jurisdiction that is ours. And such fees must be directed towards further education and training of Cayman attorneys. 6, in order to buffer against discrimination, government should provide incentives to set up small firms under 10 in order to support the sustainability and development of Caymanian law firms that have 100% Cayman ownership. 7, immediate requirement for 5 years PQE to be eligible to obtain a Cayman Islands practicing certificate. 8, commitment must be placed on into the primary legislation, and if commitments are not met, then no operational license will be granted to the firm in breach. 9, provisions for anti-discriminatory and anti-competitive practices with penal sanctions. So, Mr. Speaker, I'm still on that page. That was 2016, I believe, 2016. The problem with it is that we made those agreements within these hallowed halls in camera, but by the next morning, the then government minister reneged on them. Thus, the then premier, same one, got up and withdrew the bill because I had filed 132 amendments. Mr. Speaker, I should say to you, sir, it was the eve of the House being dissolved, yes. Mr. Speaker, I should tell the Premier and the House that I have been a little more conservative this time. and I have only filed 76. Mr. Speaker, for the benefit of the Premier, I shall repeat what I just said. I said that I should tell the Premier and the country and members that I have been very conservative this time, not 132, I have only filed 76. Mr. Speaker, a lot of those are consequential amendments though. So they're not even worthy of discussion as material amendments. Mr. Speaker, I see the Premier has filed, well, I don't see them. I haven't seen them. But based on the amounts that he explained, elucidated upon, I guess he's got a few too. But isn't that the nature of this government's tenure? Bring legislation, you got more amendments than you got clauses. That's the nature of the consultation process. I agree. But the consultation should have been. Mr. Speaker, my only wish is that the Premier, and maybe those that I heard him, many of those I heard him talk about are all that we are proposing, albeit in a different manner. But I am proposing to the Premier that maybe now, albeit not the 12th or 11th hour, but the 59th minute and 59th second hour, that we have some kind of heads together and try to eliminate those that were unnecessary. And I had a long speech, so I trust that will not be used against me now. Because, Mr. Speaker, he said that Part 11 was to be deleted by his account. I wasn't proposing the deletion thereof, but I was proposing the amendment thereof. And Mr. Speaker, let me say, Mr. Speaker, we would like to state very clearly that given the multitude of serious issues that have been faced in this profession and the jurisdiction over the past 2 decades, many of which has been ventilated in this honorable House in the past, we believe that it's imperative. In fact, Mr. Speaker, it's long overdue for this Parliament to now pass modern legislation that properly regulates the legal profession. Regulates the legal profession in a fair, transparent, and proportionate manner. Mr. Speaker, it cannot be understated and should not be misrepresented that we are desirous of ensuring the passage of balanced and meaningful legislation that is crafted in such a way that is in the best interests, absolute best interests of these islands. That is first and foremost. As well, Mr. Speaker, it must secure the integrity and reputation of our legal profession, both here and abroad. Mr. Speaker, we are very aware that the profession has never been at a lower point. Given that due to the actions of the government and the privately created and special interest control company named the Cayman Islands Legal Practitioners Association, or should I call them SILPA, in creating an unprecedented non-statutory anti-money laundering regulator called the Cayman Islands Regulatory Authority. It is no secret, and Mr. Speaker, dare I say it's irrefutable, that SILPA and CARA, since August of last year, has caused one calamity after the next, which has culminated in a number of Caymanian attorneys who has challenged this entity, whether it's legal and its legal authority, because they have been hit with huge fines by CARA. And for doing nothing more than refusing to recognize CARA's legitimacy. Mr. Speaker, that has resulted in a number of lawsuits being filed earlier this year by those same Caymanian attorneys against CARA and SILPA, and dare I say the government. Mr. Speaker, I believe that that is the background against which this bill must be seen. Mr. Speaker, we have also, this opposition has taken note that government now intends, while those lawsuits are pending, to bring a motion to obtain indemnity for the actions of CARA, which is, and of itself, very telling and very troubling to all of us. Mr. Speaker, we have to come to terms in this House with the many issues that have been heatedly debated in the past in relation to previous legislative initiatives of this kind. And like I said, maybe there needs to be the truth and reconciliation. Mr. Speaker, in that vein, I again repeat, we wish to work with the government to achieve this important legislative milestone. Provided that the government is willing to permit us to amend the bill or assist with amending the bill, as to give effect to changes that will address many of these valid concerns. Mr. Speaker, we have not been resting on our laurels, but have been working hard on reviewing and considering this bill and meeting with and consulting a number of Caymanian lawyers and others who have experience in the legal profession. And Mr. Speaker, after much consideration, have put forward these amendments, which we believe are justifiable and prudent, but are absolutely necessary in order to ensure that we do not try to fix the problems of the profession by making a bad situation worse. Now, Mr. Speaker, I should say that SILPA also asked me for a meeting. I believe in their words, they wanted to explain the bill. I took that to mean their position on the bill. And the Right Honorable Attorney General had already said to me that the Premier wanted to meet with me, despite him telling me that and saying that the bill would be gazetted in a few days, and less than 24 hours later it was gazetted. So I responded to SILPA and told them that I could meet with them, but out of respect for the Premier and his position, the Premier's position, I had to meet with him first. It's fair, that's reasonable, and it is expected of me, since this is a government bill, that I meet with the Premier first. After meeting with the Premier that day, I wrote them and said that I could meet the following Monday. But there, it was my understanding that they were wrestling with getting someone to present it to me, because their primary salesman was not on island, and they were not ready to, well, their primary presenter was not on island, and they just couldn't find anyone because of time constraints to do it with us. So I never did get to have an audience with SILPA. I have had audience with Alpha, and certainly, Mr. Speaker, we have had to ask for their support, and we have had to go on out and seek other professionals. Despite my having asked the Attorney General many times and the Premier to provide us with some financial resources to get some help, we have had to do this on our own. The Premier has on his side a battery of lawyers and draftspeople that makes it extremely easy for him to present these things. I nevertheless have to work with people who volunteer their services, or I pay for it out of my own pocket. And in many cases, Mr. Speaker, in many cases, I would have to sell all of my assets plus all of my family's assets to meet some of the costs that I am presented with. Mr. Speaker, I then I have to get that all coordinated and put in the form that is accepted on this floor. So between the members of the opposition and I, we struggle. We do struggle. But I guess my 20 years of experience has taught me that while it is tedious, I only need to stay up all night and get no sleep and then debate it the next day, as I am doing now. But that's par for the course, since there's no assistance. Mr. Speaker, and trust me, I'm not complaining, nor will the Premier have the benefit of seeing me on my knees begging. He's not going to get that opportunity, he or anyone else. I will do it because it's my responsibility as a representative to do it. I wonder who else does it in the absence of the law degree and their experiences. Mr. Speaker, we believe, and the reason I do all of this, despite not having the experience nor the resources, nor the trained ability to do it, is because I know that it is more crucial now than it has ever been to get this legislation right. So that hopefully we do not see a repeat of the past. Where the government of the day, or someone of that day, could not satisfy those in whose special interests they may have been acting. Mr. Speaker, indeed, sir, as the old adage goes, the very definition of insanity is doing the same thing over and over with the intent of achieving a different result. Mr. Speaker, we say this because despite the fact that the bill has been relabeled with a new name, it still has a number of shortcomings which caused the failure of its predecessors. Mr. Speaker, even the Premier admitted to that it is not perfect, and we understand that. But we would ask the government to carefully consider proposals, and we believe in doing so, they will see that our amendments only serve the interests of all of the people of this country. And we are genuinely, and they are genuinely designed to address the myriad of complaints that we have heard in this very hall in the past about all that ails the legal profession. Mr. Speaker, we want that 60-42. It is time, and I'll get to that. I'll get to that in a minute, Mr. Speaker. So, Mr. Speaker, we have done the necessary work to make a number of essential amendments to this bill. We have taken a minimalistic approach so to avoid too much injury in the form of the draft legislation. We have. We have done that in hopes that the government will work with us in good faith. And I say that very cautiously. Perhaps I should say in the spirit of the season that is upon us, so that we can achieve the objectives here, Mr. Speaker. We believe, Mr. Speaker, that anything less would be a failure to perform our sworn duty as parliamentarians to the people who placed us here. Mr. Speaker, it has been expressed to us by a number of Caymanian lawyers, and in particular one of our Queen's Counsel, that given the challenges in this jurisdiction now face and will continue to face in the foreseeable future, that the global fallout, we don't know what is going to happen from the global fallout. Mr. Speaker, we are also of the view that it is of utmost importance that any new legislation must ensure that the economy and the general interests of the welfare of the people of these islands is protected, and that the future practice of law by Caymanians will be guaranteed. Mr. Speaker, over the years, there has been much controversy regarding some of the prevalent practices of the large firms, which practices appear to have been both contrary to the public interest and further cause almost incurable economic harm to our country, whilst generating significant gain of a number of the owners of the large firms that operate from Cayman. The firms enjoy all of the benefits that the Cayman jurisdiction has to offer. This is nothing new. I have had that discussion with the Attorney General. And it's because they engage in these practices. Mr. Speaker, our concerns therefore is that any failure to rein in such practices in order to ensure compliance with the spirit and intent of local legislation, such as the immigration law, as well as the failure to prevent further economic loss to our country, will not only deprive current local practitioners of opportunities to have a living in the legal profession, but will cause irreparable damage to the future of all Caymanians. Mr. Speaker, simply put, given the challenges ahead, it is absolutely imperative that we get this legislation right, or as far as humanly possible, and that we do not squander the future of Cayman and Caymanians, both within and outside the legal profession. Mr. Speaker, not only the Premier has those concerns, not only he is doing this for love of the people and the country, so too are we. So too are we. Mr. Speaker, like the Premier, I believe that we all love this country. I believe that not one of the members in here can claim they love it more than any other member. But we must make sure that we work together and get this right. Mr. Speaker, in the last time we had this brought here, and I think the country needs to know this, because it's about my good friend from Savannah. And for anyone who thinks that he has not been the guide and light of keeping many of us on the straight and narrow and keeping this ship on an even keel, let me tell them about this story. Briefly pause to tell them about this story. When this bill came here as the Legal Practitioners Bill in 2016, we debated this bill, and there was the usual very, very acrimonious debate. So much so that I threatened to use section, the Standing Order 82 or 83, I think it is, to bring a motion of conflict against the sponsor of the bill. The minister pardoned at that time. And the speaker at the time was the Minister for Education. And we suspended. And everybody was angry and spewing the fire, spitting fire, like the dragons that we were. After taking a few minutes break outside, I came back and my good friend, the member from, and they wanted to hold a meeting. The Premier wanted to hold a meeting. And I said we would not be going into any meeting with them. And I was very adamant that we weren't going into any meeting because they had not properly consulted us. They had not properly informed us, and the time for meetings had passed. Mr. Speaker, I came back to these chambers during the suspension, and the member from Savannah said, I need to see you. I said, well, right now or later? He said, now. I said, okay. I went over to him, and the only thing he said to me was, you have to have that meeting. I said, really? Really? Me? He said, yes, you. That was the end of that conversation. I read out the 8 points that came out of that meeting. That meeting was caused by the member from Savannah. The Right Honorable Anthony Eden. So if you think that value that he has is not important in here, try it again. And I dare say, Mr. Speaker, that there's not one man or woman within these hallowed chambers as members that does not respect that. That is the reason that meeting was held. Of course, the Premier was shocked that I approached him and told him that the meeting was going to be on. To this day, he did not know what caused that meeting to happen. That was the member from Savannah, Mr. Anthony Eaton. Mr. Speaker, we are again opposing the provisions of mass wholesale licensure of hundreds of persons currently holding themselves out as Cayman attorneys. All of whom we believe hitherto, as the Premier has said, have been operating outside the jurisdiction without any form of oversight. That's not to say that we are not proposing a way that we can do this. Mr. Speaker, the Premier talked about how not about the economic fallout and not registering these people now and the explanation therefore. Mr. Speaker, I believe it's simple because we are of that same view to some extent, that if we license everybody and there is an economic downturn, now we could very well be with the lawyers overseas, albeit that provision in their one-to-one means they would have to contract if ours lose their jobs as a result of an economic downturn because of this pandemic. Because, Mr. Speaker, all over the world they're downsizing. Law firms are downsizing. I get articles from England, they're downsizing law firms. Hopefully it's only those overseas. But certainly if those overseas are downsizing because of the lack of work, then ours are going to punish as a result thereof. So I think that's a simple answer that I can provide for the Premier, that why people are saying that. And I think it's a reasonable answer, reasonable position to be taken. How we address that, we need to decide on how we address it. But certainly, Mr. Speaker, we cannot leave it alone. Because, Mr. Speaker, overseas practice of without any oversight or regulation flies in the face of the legislative intent, I believe, of our immigration legislation. Mr. Speaker, we believe, and our amendments will reflect that these people should have work permits. Mr. Speaker, it is a requirement in BVI, but yet we are told that it would put us out of reach out of contention with our competitors. BVI required them to have a work permit. But we don't hear that unless we do the research. Mr. Speaker, the other one that we are concerned about is, and the Premier spoke of it, the prevalence of foreign-owned and controlled law firms and or legal practice corporations in Cayman, especially in recent years. Many of whom have arrived here in the last decade. It's either they're here to buy out existing law firms, establish law firms, or to set up Cayman office of a much larger foreign-owned and controlled, quote-unquote, global firm, where upon establishing themselves in the Cayman jurisdiction, they can use their global presence and sheer size, Mr. Speaker, to engage in unfair competition with established local firms of all sizes. Despite the Premier saying that there is sufficient room for everybody to operate, we cannot have that kind of predatory behavior within the legal profession, people coming in here and doing it. And Mr. Speaker, I have heard of, and this is one of the things the law must address, and I believe if we can sit down with these amendments, it will address it as well, further address it. You have people coming here on work permit, working with a law firm, get their practicing certificate, fall out of sorts with their employer, and go out and start a partnership and create a law firm without Caymanians. Now, I understand the legislation will address some of that because that law firm, as an employer, would have to notify what the latest utterances from the Premier that it's going to be turned into a council. We are proposing an authority, which may not be much difference if we get the same objective. But we certainly not going to support the Chief Justice being on it. No, I'm not going to do that. Mr. Speaker, we must ensure that all legislation that is promulgated by this Parliament serve the interests of people of these islands. And anything less than that would be a reckless disregard for the economic interests of all persons living here, save and except for those few who will continue to reap the massive profits of such enterprise. Mr. Speaker, have created this thing ourselves. That is the prevalence of foreign-owned and controlled law firms in our country. We may have created that ourselves by us practicing overseas in their jurisdiction. I think we like to call that word reciprocity. I guess they feel like they have a right to come too. Maybe we have provoked that form of law practice in this country by virtue of us having Cayman law practice in their country. And Mr. Speaker, the Premier says that that's what it attracts, and it makes us more attractive, and it has increased the law firms, and it has increased the amount of lawyers from 165, I believe, in 95, I think he said, if I'm wrong. I think that's what he said. In 163 in 95 to around 900 now. That's what he said. I wrote it down. Mr. Speaker, that's all well and good. But when we have no control over them, wherein every business in this country, if either Caymanian wants to do a little landscaping company, he has to prove that it's 60-40. Now, I would like to know, Mr. Speaker, what glorified position does lawyers have that they don't need to be under 60-40 too? Or controlling shares being owned by Caymanians? Now, Mr. Speaker, we know the purpose of any lawyer is to find loopholes in what we do here. But certainly, Mr. Speaker, we can at least require them to operate in accordance with the trade and business license law. How can we tell our people, tell others who come into the LCCL now has become an aberration of sort too, because everybody and his brother and sister has that now. I remember when there were only 6. Now we got hundreds of them. Even if you want to buy an apartment, you can come here and get an LCCL. So it's no longer a special privilege. It appears like it's an open opportunity. Mr. Speaker, we cannot tell our people that they, whether it's fronting or otherwise, must provide proof that they have 60% ownership or the majority ownership in any little company they want to form. But you only need one person to form a law firm. You know, Mr. Speaker, the irony of all of this is that there are very few law firms in this country that cannot meet that threshold. And if we give them time to do it, what does that do? That brings Caymanians up. If we give them time with cabinet or the authority or the council, whichever one we're going to name that to be, having the authority to manage that and watch it. Mr. Speaker, here's what is going to happen. In the cycle of human nature, we all must die. So those who are there now must at some stage retire and fade into the sunset. It gives the Caymanians the opportunity to come up and fill those slots. I am not convinced, Mr. Speaker, that the only cadre of Caymanians becoming lawyers that could make partnership of people like the Premier, Wayne Patton, what is it, Reed, Banks, the lady, the one name it? The twin, Wanda. Nobody's going to convince me that ability just dropped off the edge of the earth. That we were all running fast a precipice to get lawyers in this country. We created the law school in the early 80s. And all of a sudden, we just went off the precipice. No one is going to convince me of that. This thing must be in perpetuity, Mr. Speaker, and we as legislators must ensure that we make the provisions now since we're doing it. And I believe making those provisions lies within a requirement of the LCCL or the Trade and Business License Law. Are you going to tell me they're not capable? Caymanians, yet. We speak so passionately about the accountants and how they can cooperate and they can agree on self-regulation. Our lawyers can't do it. You know what I cause that? Greed. Greed. And mistrust. They do not trust each other. Yet we speak passionately of the Minister for Finance. Mr. Speaker, he too, he is a Caymanian, you know. Then we speak of Dan Scott. We speak of Jude Scott. We speak of the man Small and Johan Small. We speak of the young lady Hislop. We speak of this one. We speak of that one. They're all Caymanians. You know why they can do it? They were given the opportunity there to do it. Mr. Speaker, you cannot tell me that those can do it and it's a requirement in their field and in their industry, in their profession, to uphold Caymanians, and we won't require it of the lawyers? Is there a special breed that you need to be a lawyer? and Caymanians don't have it in them? Mr. Speaker, I dare say that Caymanians come from good breeding stock, and they can be anything they want to be if given the opportunity to do so. Mr. Speaker, I used to know this see one little fella around Georgetown in this GQ suit all the time. And I wondered who the world is this little fella. And I say he's so pompous. So my nephew had a little problem with the liquor licensing board, I believe. Mr. Speaker, I went with my nephew because I'm going to defend my nephew now. And he said, Uncle, my friend, come and help me with it. I said, okay. I said, is it a lawyer? He said, yes, sir. So, waited. Just before his matter came up, this little fella with all his GQ suit walking, I wondered where he going. I said, really? I said, JJ, you know him? He said, yeah, Uncle, that's my friend. Your friend? You think he can defend you, yeah? You can see. He too pompous to even do that. Of course, that's what I said to my nephew. Mr. Speaker, that little GQ man got up in front of that board and my mouth dropped open. And it stayed open for a long time. And it's still open. So much so that I have referred everything I know to him. But he's Caymanian. That's what we do. We all do that. We put this label on people. And I did, but I admit it. And I've since apologized to that GQ man. Richard Barton. I've since apologized profusely to that gentleman of that I had put a label on him. I didn't know who he was, Mr. Speaker, but I knew he liked the GQ suits. But we do that throughout our life, and I have a right to do that, but when I find out that that is not the true identity of that individual, then I need to apologize. And I need to give that person the opportunity to prove themselves. But we are not getting that. While I should not have done what I did, others are using it as a mark of the beast to keep Caymanians down. And they're not getting the opportunity. Mr. Speaker, I can tell anyone that little GQ man, Richard Barton, is a good lawyer. I don't know what, I believe in litigation. But then there are others. CG.
That's a good place to stop right there.
Thank you, sir.
We will take our evening break. So the House will suspend until 6:30.